All right, Ahmed. So I think to start here, maybe just start with like a high level summary. Like, what is adjustment of status? Now it's available under the RIA. What does it give you? And maybe mention the visa bulletin, and then we'll just kind of talk through this slide.
Absolutely. So I think, a lot of investors, when they're first looking at the EB-5 process, there's a lot of numbers thrown at them, specifically in the form of form numbers from USCIS. And, they definitely don't make it easy in terms of how many different forms there are. And I think a lot of times investors get confused as to what is what. I get a lot of investors that think, an EAD is the same as the conditional green card. So what we've done here is kind of broken down the different form numbers, okay? And let's talk about what each of them kind of do, how each of them get filed, what the basis for the approval is for each one, and then we'll kind of talk about why each one is a little bit significant in its own right. The first one and the most basic one is the I-526E. This is basically the same as an I-140, which a lot of investors are already familiar with if they're in the U.S. and work, in H-1B or L-1 status and have an employer filed EB-2, EB-3, and even EB-1 application. So it's an underlying benefit that the government is granting in which you would be approved for a green card. Here, the 526E, instead of a labor certification or anything like that, you're purely showing the government where your money came from that you've invested, where that money is going, the project that you're investing it into, and then some general biographic information. Okay. Now, one of the big advantages that the RIA created for investors who are already in the US is when you file a 526E, as long as you're current on the visa bulletin, you can now also concurrently file. And concurrent filing basically is you now get to file an adjustment of status. This is only available to investors who are in the US already in a qualifying visa status. This could be, H-1B, L-1, it could be E-2, it could be a TN, it could be an F-1, it could even be a B-1, B-2 in some cases. So if you're in the US, you now have the option to file an adjustment of status at the outset, right? Normally what a non-concurrent filing would be is that you file the 526E, several months later, once you're approved, now you can file the adjustment of status. So what the government basically did was give everyone the advantage of, hey, you don't have to wait for approval. The same day that you're filing the 526E, that initial application, you can now also include the adjustment of status and get that in with the government. Now that alone doesn't provide a lot of benefits. One big benefit, I guess, is that it does give you status in the US. So let's say that you file the adjustment of status and then you're laid off from work. Most people have a 60-day grace period to figure out a new job. Well, with the 45 already filed, you don't have to worry about that 60-day grace period. You still have status in the US even beyond that initial 60-day grace period. And the second one, and something that we'll talk about in a little bit, is that if you have children, you can now lock in their age potentially for life, just with that adjustment of status filing. So some pretty, although there's only a couple of different advantages here, they are pretty distinct and they're very important for investors who are considering the EB-5 application. Along with that 45, and this is where a lot of the immediate benefits come in with an EB-5 filing. Along with that adjustment of status application, you get to file two more, and this is where the 765, which is an EAD, Employment Authorization Document application, and then you also get an I-131, which is going to be requesting an advanced parole, which is a travel authorization. Okay, and a lot of investors are like, oh, well, what's the likelihood that I'll get the EAD and the advanced parole? What's USCIS looking at? They're just looking at the fact that you filed an adjustment of status. So that 45 going in and pending under an immigrant category gives you the ability to now have a work and travel permit in the US while you're waiting for that to come about. So this is especially important for investors who are considering like the high unemployment urban area projects, especially if they're from India or China, but they happen to be in the US. They can still secure their future. They can maybe, take advantage of some of the slightly better terms that those projects offer. And until they get it, let's say it's 5, 6 years into the future, they're going to get this EAD, they're going to get this travel authorization and be able to live and work and travel in the US until they actually get their full green card. So, from a benefits perspective, you're essentially getting the same benefits you would with a green card very early on. And we see here with kind of this chart and showing, the processing timelines. It's a very, very short stint before you get your 765 and I-131 approved. Typically, we're seeing somewhere between 3 to 6 months for most people to obtain those cards and start working on them if they would like to. The 526E and the adjustment of status might well take, another year or sometimes even two. But in the short term, in the interim, while you're waiting for those approvals to come through, the government is going to give you permission to work and travel and basically start your life in the US. The last, real form that people need to worry about is the I-829, which is the petition to remove conditions. The question I get a lot is, what does it mean to be a conditional permanent resident? And the answer is, it's a full permanent residency. And actually, it's a very similar process that you go through if you married a US citizen. You are still a conditional permanent resident initially, and then usually about 2 years later, the government comes in and checks, are you really married? Is this a bona fide marriage? With EB-5, they're doing the same thing, except instead of checking if you're in a bona fide marriage, they're checking to see if you've created the necessary jobs and sustained your investment for the necessary period in order to remove the conditions. So this doesn't happen until much later into the process. You get your conditional green card first. You hold it for 21 months, and that's when the window opens. And you've got a 3-month window basically to file that I-829. Your immigration attorney will handle that. And as a regional center, we are responsible for most of the information that goes into that filing because it does track your investment. It does show how your investment was ultimately spent in the project and how that expenditure then directly correlated to the job creation that the project creates. So yeah, these are all the different forms. And we talked about the EAD and advanced parole being kind of the immediate benefit. And the question, I'm sure, Sam, you can attest to this as well. We get a lot of questions about, well, what's the difference between getting an EAD and an advanced parole and a conditional green card? In terms of what I'm able to do in the U.S. and able to kind of do in terms of work and travel. What's the difference? And the reality is there's not much, right? Once you have that EAD in hand, it's a 5-year EAD. You can renew it for as many times as you need to until you get the green card. So it's a long-term EAD. You don't have to renew it every other year. And it gives you the ability to work anywhere in the US for as many companies as you'd like to in the US. Or, and I think this is kind of a hidden benefit, is you don't have to work. If you wanted to take 6 months off and spend time with your family, you don't have to worry about losing your status in the US because it's tied to your employment. You can do that and just kind of hang out at home and then go back to work at a different time. Let's say you wanted to start a company. Let's say you want to start 3 companies at the same time. You're free to do that with an EAD. You're even free to work for a company and have your own company on the side that you're starting up. So the EAD gives you broad work authorization, the same that you would have essentially with a conditional permanent residency or a green card. And it really allows you to do that very quickly. The other benefit that it gives a lot of folks is the ability to get a social security number, right? So if you're newer in the country and maybe you haven't, started working yet, a lot of times students have this kind of issue. You can now get a social security number, and this will really help you in terms of if you wanted to start your own business, having more banking opportunities. If you wanted to buy a home, having just something on the record that allows you to go to a bank and apply for loans and things like that. If you wanted to, get into trading and things like that, you need a social security number often to be able to qualify for a lot of those activities. So getting that EAD really is, within 3 to 6 months, you can have the same benefits that a green card would grant you with an EAD. So it really is a huge advantage to get that card. The advanced parole, I think the main warning that a lot of immigration attorneys will give is when you file an adjustment of status, people do want to travel, they do want to have flexibility. Getting that advanced parole is kind of the key point when you can start traveling again. If you travel before this, you're going to abandon the advanced parole. In some statuses, that might also mean abandoning your adjustment of status. So this is a pretty key document. Once you do have it, yeah, you've got authorization to travel pretty much anywhere in the world and return to the United States. And it won't affect your pending 485 application. And yeah, I think it's the big advantage here is if you're from a backlog country or countries where it is very difficult to often get a visa stamping, right? If you're Indian in the U.S. and you've been on H-1B the last few years, especially since COVID, you know how difficult it can be to sometimes go back to India and get an H-1B visa stamp and then return to the U.S. That's why they're talking about possibly having a stamping done domestically now. This kind of solves that problem, right? An advanced parole now allows you to travel and return with no other visa stamp in your passport. There's ramifications of traveling on an AP in terms of you will no longer be in whatever status you were previously, like an H1 or an L1. But this is something to discuss with your immigration attorney. And I think the biggest way that I can explain it is you have the option, right? If you do have a visa from a different category, you'd like to sustain that, you can continue to travel on that. But having the AP gives you that peace of mind that if there's an emergency, you don't have a visa stamp, you can travel and re-enter the US without worries of being denied entry at the border. And then, lastly, we come to the Child Status Protection Act. And I think this is one of the biggest benefits that has kind of come about in the last couple of years. In a nutshell, what the Child Status Protection Act is, it's a law that was passed, many years ago that essentially tries to protect children from aging out. And aging out basically means that once you turn 21, you're no longer listed as a dependent on your parents' application. Okay. And so what we see in a lot of categories is because of longer wait times for processing purposes or because of backlogs, someone might apply for a green card when their kid is 14, 15 years old. But by the time they're actually receiving that green card, the child is now 22, 23, 24 years old, and they've aged out. And so what CSPA, or the Child Status Protection Act, tries to do is address that and then help those children to retain dependent status even after they become 21, as long as the application was filed at an earlier stage. Now, the most basic protection that CSPA offers is that while you have an immigrant petition pending, and this could be an I-140, but in our case, we're talking about EB-5, so it'd be the 526E. The whole time that case is pending, your kid does not age further. Okay, so to illustrate this, let's use a real life example. Let's say you filed an EB-5 application that was received on your child's 18th birthday. Okay, and it takes 2 years for the 526E application to be approved. Let's just use an easy number here. Now, in reality, your kid is aged 20 years, right? But in the government's eyes, that whole time that application was pending, your child didn't age a day. So at the time of approval, your kid is still 18 because that's when you filed the application. Okay, so in the government's eyes, there's a CSPA age, and that age is often much younger than their real age because their age was frozen by an immigrant petition being filed. Now, here's where things kind of get a little bit tricky, and what really people start to lose their understanding. At the time of approval, if you're current on the visa bulletin, so you filed an EB-5 application, your kid's age was frozen, now that you're approved, you look to the visa bulletin, you're current. On that day, you get a 1-year period that starts, and within that 1-year period, a child could basically file an adjustment of status, pay a fee bill. In some special situations, you could file, I believe the form is an I-824, to basically push the consulate to issue a fee bill. There's a few different ways that you can seek to acquire LPR status, lawful permanent resident status. Okay. Now, what makes this very interesting is that you're now concurrently filing in the 526E category. And USCIS in a policy memorandum 2 years ago basically came out and said, we're looking at the filing of the 485 date as the date that we're going to use for CSPA purposes. Okay. And so the prevailing sentiment within the industry, within attorneys, even with other things that USCIS has said over the last year, different statements that they've made, it seems like now a concurrent filing will essentially lock your child's age forever. Okay, so if let's say your child is 20 years and 300 days old and you're filing an EB-5 application right now, as long as the visa bulletin is current and you're able to file that adjustment of status and get that accepted, even though your child is, technically going to age out in just 3 months or 2 months, yeah, in 3 months, you're actually in good shape to now lock your child's age in forever. And if we look at this from a logical perspective, this actually does make sense. You know, if let's say that you file the application and then it backlogged, right? So when you're approved, you're actually backlogged, and then let's say it takes 2 years for it to come out of that backlog for you to become current, and in that time, your child has aged, significantly, and now they have to seek to acquire. Well, there's nothing that they could do, right? The adjustment of status has already been pending. There's no additional step that they would have to take. So it makes sense that that original filing would basically lock in their age, and that's what USCIS is going to be looking for. Um, with this being said, there is no official written guidance on this, and I would definitely speak to an immigration attorney before making any kind of final decision, based on this. But if you're kind of in a situation where your child is very close to aging out, not taking a step like this means that they're definitely going to age out, right? So I will take a chance that they will not age out, a very good chance that they will not age out, over the certainty that they will definitely age out any day. And I think that's the way that a lot of immigration attorneys have presented this to investors, and how a lot of investors have actually taken advantage of this new provision, this new guidance that USCIS has given over the last couple of years. And it's definitely an evolving subject, but one I think that's trending in the right direction. And then the purpose of Congress always was to protect children from aging out where it was unfair to the children. And it seems like this provision and this rule and this interpretation really does accomplish that.
Ahmed, let's talk about a real life example. Given that currently we expect the urban reserve category to backlog, pretty significantly for Indian and possibly Chinese investors as well. So, yeah, let's say you're an Indian family, you're in the United States now, you have a child who's 20 years old, and you decide in February of 2025 you want to invest in a urban project. The visa bulletin is current, and so you do your filing, and then walk us through kind of how this rule would help protect that child.
Yeah. So let's say, so to Sam's example here, we've got someone who's got a kid who's 20 years old, very close to aging out, right? They know that in the next, let's say 3 to 4 months, the visa bulletin is going to retrogress, and basically they won't be able to concurrently file. So let's look at two scenarios. One where they file their EB-5 application before the visa bulletin retrogresses, and one after, right? So the kid is 20, they file, let's assume that they filed in the next month, and they're able to concurrently file and get their adjustment of status filed. Even though their kid is 20, that kid is now age 20 for the rest of however long it takes to get their green card. Let's say it takes 7 to 8 years to get their green card, even though the kid will technically be 28 years old in real life. In the government's eyes, thanks to CSPA and the way that USCIS is interpreting a lot of these rules now, that child is still 20 and able to get the green card as a dependent. So by filing concurrently before the 21st birthday of the child, they have essentially protected this child from aging out ever. Okay. Now let's look at someone who basically didn't file concurrently. They've waited 5 months now. They're filing their 526E application. They're saying, okay, well, whenever it becomes current, I'll get my adjustment of status in. I just want to take advantage of the EB-5 and secure my future. Sure, that's still an option, but now they haven't locked the child's age, okay? So they filed the 526E. The 526E does actually lock the child's age in the interim until it's adjudicated, okay? But let's say the 526E is adjudicated in 2 years, and it takes another 2 years after that. We'll be super optimistic and say it takes only 2 years after that for them to become current again. At that point, the child has actually aged out. And the reason for that is, while their age is locked during the 526E adjudication period, once you get approved, if you're not current, the child continues to age out. Okay. And so They only had a year of wiggle room here because the child was 20 at the time of filing, and that year, passes by. They're not current. The child is now aged out. So even though they filed their EB-5 application before the child turned 21, because they didn't file the adjustment of status, that concurrent filing before the child turned 21, they were unable to lock the child's age in forever. So this really illustrates just how important it can be to get a concurrent filing in. And especially over the next several months, as we're seeing the visa bulletin, possibly retrogress in multiple categories for multiple countries, there really is just no time like the present if you're looking to secure your child's future. And if you're in a high unemployment area project, if you're looking at a high unemployment area project, this could very well mean, if your child is even like 16 or 17 years old, it's time to really get that concurrent filing and to lock in their age. For rural, we're not expecting it to be that bad, but definitely if you're a high unemployment filer at this point from India or China, the choice is clear. You've got to move faster rather than later to be able to lock in your child's age and afford your family all the protections that the concurrent filing gives.
Got it. Thank you, Ahmed. And so if the visa bulletin does show a backlog for urban high unemployment projects, then once that happens, future applications for investors who do want to avail themselves of this benefit, they would really only have one option, which would be rural projects likely, or vice
Yeah,
versa, whichever reserve visa category remain current. That's the only
right.
way they'd be able to lock their child's age with an adjustment of status in a
Right.
category where it was current.
Right. And if you think about this even further, it's really a golden opportunity right now because if you, India is a great example. They're backlogged in almost every category, EB1, EB2, and EB3. So they're not able to concurrently file in any of those categories, right? And for EB2 and EB3, they're not going to be able to file concurrently for a long time. EB1 is backlogged a few years and hasn't moved much over the last year as well. EB5 is the only way that you can concurrently file right now and lock in your child's age forever. It's if you're Indian, that's the only way. So yeah, for a lot of families that are kind of considering this and wondering about their children who have children who are in that 19 to 20-year threshold, this is it. If it backlogs and you're unable to protect your child in the next, year or so, there's a very good chance that they're going to age out. You're not going to be able to avail yourself of that protection. So this is kind of go time if you're an EB5 investor or potentially EB5 investor looking to secure your child's ability to adjust alongside you.